Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today's case, Olivier versus City of Brandon, Mississippi. Decided March 20th, 2026. The Supreme Court ruled 9-0, unanimous, that a person previously convicted under a law can still sue in federal court to stop that law's future enforcement. Justice Kagan wrote for the full court, no concurrences, no dissents.
The practical punchline: if the government convicted you under an unconstitutional law, you can still go to court and say, "Stop enforcing this against me going forward." That means Olivier can walk back to that amphitheater sidewalk, loudspeaker in hand, and preach without looking over his shoulder for the Brandon police chief.
There's an interesting Greek reference in this opinion I can't wait to get into. The Supreme Court dusted off Homer's Odyssey to explain exactly why people like Olivier deserve a path back to court. Before we go further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
Here's what you need to know. Gabriel Olivier is a street preacher in Brandon, Mississippi. He's a devout Christian who considers public preaching a core expression of his faith. He frequented the sidewalks near a public amphitheater in Brandon, where large crowds attending events gave him a ready audience. Signs, loudspeaker, there to talk to people.
And that caused friction.
It did. Others showed up there too, and the activity drew disruption complaints. So in 2019, Brandon enacted an ordinance, a local law, requiring anyone there to protest or demonstrate around the time of a scheduled event to stay inside a specially designated protest area.
Which sounds reasonable on its face.
Maybe. Except when Olivier checked out that protest area in 2021, he concluded it sat too far from the crowds to reach anyone. So he returned to the sidewalk fronting the amphitheater, signs, loudspeaker, and the Brandon police chief arrested him for violating the ordinance.
And then what?
The following month, Olivier pleaded no contest in municipal court. He didn't admit guilt, but accepted the punishment. The court hit him with a $304 fine, 1 year of probation, and 10 days in jail. Those 10 days only triggered if he re-violated the ordinance during probation. He paid the fine, served no jail time, didn't appeal.
But he still wanted to go back.
Exactly. So instead of risking another arrest, he filed a federal lawsuit under 42 U.S.C. Section 1983, the main federal law letting people sue state and local officials for violating their constitutional rights. His argument: this ordinance violates the First Amendment's free speech clause by forcing speakers into a zone where they can't reach anyone.
He asked for two things: a declaration that the ordinance violates the Constitution, and an injunction, a court order, telling city officials to stop enforcing it. No money, no overturning his conviction, no clearing his record. Just let me go back to that sidewalk without fear of arrest. The whole lawsuit pointed forward.
Entirely. Which drives everything that follows.
In the lower courts, Heck and the city grappled over the scope of a 1994 Supreme Court decision called Heck versus Humphrey. The district court in Mississippi dismissed the case in September 2022. The Fifth Circuit affirmed in August 2023, saying Heck bars any Section 1983 claim where winning would necessarily imply the invalidity of a prior conviction. If the ordinance is unconstitutional, Olivier never should have been convicted. Dismissed.
But there was a significant dissent. 8 of 17 Fifth Circuit judges dissented from rehearing. They argued Heck only blocks backward-looking suits, ones trying to undo a prior conviction. A suit seeking only a forward-looking injunction? Totally different. And the Ninth Circuit had already ruled that way in a 2019 case called Martin versus Boise. Circuit split, where different federal courts of appeals reach opposite answers. And that's exactly what pulls the Supreme Court in.
Got it. Let's get to legal issues. The court had to answer whether Heck blocked a civil rights lawsuit when the plaintiff only asked to stop future enforcement of a law, not to undo a prior conviction.
Let's unpack Heck, because that's the whole ballgame. Heck, 1994, involved Roy Heck, a state prisoner serving 15 years for manslaughter. While his appeal was pending, he sued 2 prosecutors and a police investigator, claiming they destroyed exculpatory evidence to get his conviction. He wanted money damages for that.
He wanted to get paid for a wrongful conviction.
Yeah. And the Supreme Court shut Heck down, Strip away the damages label, and what Heck's lawsuit really did was attack his conviction through the back door. The court called that a collateral attack. The court directed him to habeas corpus instead, Latin for "you shall have the body," the dedicated legal channel for challenging the fact or duration of imprisonment. That channel exists precisely for this. Section 1983 doesn't substitute for it.
And the real danger the court saw was conflicting outcomes. Criminal court, conviction stands. Civil court, here are your damages because that conviction violated the Constitution. Two courts, one set of facts, two irreconcilable answers. The Heck court wouldn't allow it.
So why doesn't Heck apply to Olivier?
Olivier did none of that. He sought no money. He never touched his 2021 conviction. His lawsuit pointed entirely forward. This ordinance violates the First Amendment. Stop enforcing it. No collateral attack, no conflicting judgments, no habeas overlap. The problem Heck solved simply never materialized in his case.
For these reasons, Heck had no toehold into the situation. Justice Kagan reached back to a case that already resolved this question, years before Heck arrived. Woolley versus Maynard, 1977. George Maynard, a Jehovah's Witness in New Hampshire, covered the "live free or die" motto on his license plate with tape. It conflicted with his moral and religious beliefs, in violation of state law.
3 convictions, fines, short jail terms. After completing all of it, Maynard filed a Section 1983 suit in federal court. Declare this statute unconstitutional, stop enforcing it.
And New Hampshire fired back. "We convicted you 3 times under this law. You don't get to walk into federal court and challenge it now."
The Supreme Court disagreed. Maynard sought only wholly prospective relief, freedom from prosecution for future violations. His suit reached nothing backward. Section 1983 opened the door, but the court went further and named the stakes. Without that avenue, Maynard faces Scylla and Charybdis, straight out of Homer's Odyssey. The 6-headed monster on one side, the deadly whirlpool on the other. Either violate the law again and suffer the consequences, or permanently surrender speech the Constitution protects. The court refused to force that choice, and Woolley controls Olivier's case directly.
This is where Kagan looped in a Greek mythology reference. You've been sitting on this?
I have. The court reached into Homer's Odyssey, nearly 3,000 years old, for the right image. Odysseus steering between Scylla and Charybdis. Scylla, the 6-headed monster, grabs sailors off the deck. Charybdis, the whirlpool, drags entire ships under. No clean path through. You pick your catastrophe. The court said that's exactly where Maynard stood without Section 1983. Go back and preach, violate the ordinance, face prosecution again. Scylla, stay silent. Walk away from speech you believe the Constitution protects. Charybdis. The court refused to leave him there. It refuses to leave Olivier there either.
3,000 years of literature, still pulling weight in a federal courthouse in 2026. And it sets up the city's counter-argument perfectly, because the city came armed with its own textual hook from Heck, and it deserves a serious look. The city anchored its position to one sentence from Heck. If winning a Section 1983 suit would necessarily imply the invalidity of a prior conviction, the court must dismiss the complaint. Justice Kagan conceded, strictly speaking, that language reaches Olivier. If he wins, his 2021 conviction logically falls as unconstitutional. But she applied a bedrock interpretive rule: read judicial language against the circumstances actually before the court when it wrote those words. Heck deployed that sentence to smoke out disguised attacks on prior convictions. Lawsuits dressed up as something else, but aimed at unwinding a conviction through the side door. Olivier's lawsuit does none of that.
And the court constructed a hypothetical to expose the flaw. Picture a citizen they called Lawrence, clean record, 0 prior convictions, who sues Brandon to enjoin the same ordinance. Nobody claims Heck blocks Lawrence, but under the city's logic, it should, because Lawrence winning would also necessarily imply that Olivier's conviction was unconstitutional. The court called that result ludicrous, and that absurdity proved the necessarily imply language cannot stretch that far.
So what did the court hold?
9-0. The court reversed the Fifth Circuit. Justice Kagan for a unanimous court. Heck versus Humphrey does not bar a Section 1983 lawsuit seeking only prospective relief, a declaration that a law violates the Constitution, and an injunction stopping future enforcement, even when the plaintiff carries a prior conviction under that same law. Olivier's suit proceeds. The case returns to the lower courts to decide the First Amendment merits.
Every justice signed on. Clean 9-0.
All right, what this actually means. So what actually changes? For street preachers, protesters, leafleters, anyone engaged in expressive activity in public spaces who ever faced arrest under a local ordinance, this ruling opens a door the Fifth Circuit slammed shut. You no longer choose between two bad options: risk another criminal prosecution or permanently give up your First Amendment rights. And it ripples well beyond street preachers. Anyone who received a conviction, paid a fine, did probation, moved on, under a local law they believe violated their constitutional rights, can now bring a Section 1983 lawsuit to stop that law's future enforcement. The prior conviction no longer blocks the courthouse door. Cities and local governments feel this too. They can't use a citizen's prior conviction as a procedural shield to prevent constitutional challenges from ever getting heard. If the ordinance violates the Constitution, a court can say so and stop enforcement going forward. And the court deliberately left one question open, which means it's coming back. The court assumed Olivier never sat in custody for his conviction. It reserved the question, what about a person currently in custody for violating the challenge statute? Can they bring this kind of prospective Section 1983 suit? Because habeas corpus might still dominate that scenario. That battle comes in a future case, but for everyone who served their time, paid their fine, completed probation, and still wants to engage in the activity the law tried to restrict, Olivier says, you can fight back. The court refused to let a prior conviction become a permanent gag order on future constitutional challenges. Gabriel Olivier can go back to that sidewalk outside the amphitheater in Brandon, Mississippi, signs, loudspeaker, and all, and fight for his right to preach there without fear of arrest. That fight continues in the lower courts. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. And look, if you don't subscribe after a unanimous Supreme Court win for a street preacher with a loudspeaker, a $304 fine, and a mythology reference in the opinion, we genuinely don't know what else we can do for you. Talk to you soon.